to you. Now, there we go. I'm able to advance. Michael circulated these problems to you, so it might be good to have them accessible while we go into the breakout groups, so that you don't have to come back and forth, into the main area. It may be hard to find your way back without the breadcrumbs to your breakout group. So if you can pull those up and be able to review them in your breakout groups, that would be helpful. So Paulina, a lawyer at a private firm, is working on a matter on a volunteer basis with her justice. The client was recently terminated because of business losses at her employer due to COVID-19. Given her work in the sharing or gig economy, however, she's having a difficult time accessing unemployment benefits. I'm sure none of you have a client who's in this situation. The lawyer would like to make a donation to the client to help sustain her economically until the unemployment assistance issue can be resolved. Can the lawyer give money to her client? How about making a donation of other items like groceries, household products, or gift cards to a grocery store directly to her client? Are there any prohibitions on her doing so for any or all of these actions? Are there any requirements she must follow before she does so? Like having the money sent through her justice or another nonprofit? Is the lawyer obligated as well, or instead, to assist the client with the unemployment matter in lieu of providing assistance? So an old idea in legal ethics is the most ethical thing to do in terms of legal ethics is perhaps the second most moral thing to do in a given situation. So here, are you relegated to simply assisting her in squaring away the unemployment issue, or can you give financial assistance to your client? Is it better simply to help with the unemployment matter? Are you obligated to assist with the unemployment matter in addition to or in place of providing financial assistance in some form? And if you do think you can give financial assistance in some form, what should that form take? What can that form take, if any form? So Michael, if you would wave your magic wand and send people out to their breakout groups, that would be great. And you'll get an invitation to accept being sent out to the breakout group. So please accept that when Michael does that.
Ray, how many people per room?
4 or 5 is fine.
4 or 5, okay.
So in this first breakout, introduce yourselves if you don't already know each other. Hopefully we'll get mixed groups and then try and tackle these problems. See you soon, everybody.
Richard, I think you have to accept the invitation to the breakout room.
All right, Mike, let's give it one more minute.
Yep. All right, you can bring him back.
Sure. All right.
Just waiting for a few more people.
Yep. All right, I think we're all back. So I'm going to go back to sharing screens, but then Caroline, I'm going to go to you first. I'm going to pick on you first to see what your group said. Oh, and there's an attendance. I am still here.
Sorry about that.
No,
I got a
that's
call.
okay. So you'll see the attendance. So please plug into the attendance. So Caroline, so we had, I only asked you the first sort of cluster of questions about the financial assistance. What do you think? Is it okay to give your client financial assistance? Does it matter? What did your group say?
So I came from a place of ignorance, which I'm not ashamed to say, because I know that I heard that there was some change in the rule, but I did not really pay attention to it. So luckily my group was much more informed than I was and knew that the rule has been changed and that lawyers now can provide assistance, both financial and otherwise, to a client under a humanitarian exception, and that there is no limit to how much you can provide, and you can like pay rent or get groceries or gas or really anything that your client needs. And we did have some discussion about whether the money should be through Her Justice or as an individual donation. And Esther had a client, a PBA who had wanted to donate through Her Justice, probably for purposes of a tax write-off. And we haven't made any decisions as an organization, but that's less of an ethical question and more of like we don't normally do that, but should we? And that's kind of a separate discussion. And on the unemployment front, there have been concerns, from a lot of PBAs that I work with, and I think that everyone works with, about what is the scope of the representation, how much stuff needs to be included in their retainer, and if it's not included in the retainer, do they do it anyway, or do they need a separate retainer? And Esther had mentioned getting a new retainer for the unemployment portion of things. I have advised my PBAs generally that if they're doing it just as like a nice thing that you are doing for someone, not in a legal capacity, that they probably don't need a new retainer, and that they can just assist on it, because it's not really a legal issue so much as it is just like a figuring out how to work a complex system.
So let's all that's great. Let's talk about the financial assistance first, and then we'll get into some of the issues you raised with the assistance with the other related matters. So you're absolutely right that the New York recently changed its rules. New York some states allow for financial assistance. New York had not until recently, literally in the last few months. So here's the unrevised portion of Rule 1.8. So Rule 1.8 deals with conflicts, current client contact conflicts, and it goes through a lot of different areas where a conflict can be present, and then it looks, E looks to financial assistance. And so, well, first I'll read the unrevised portion. Forgive if the slide is misleading, but on this first slide, this is the unrevised portion. A lawyer may advance court costs and expenses of litigation, the repayment of which may be contingent on the outcome of the matter. A lawyer representing an indigent or pro bono client may pay court costs and expenses of litigation on behalf of the client. A lawyer in an action in which an attorney's fee is payable in whole or in part as a percentage of the recovery may pay on the lawyer's own account court costs and expenses. In such case, the fee paid to the lawyer from the proceeds of the action may include an amount equal to such costs and expenses incurred. So none of this, we're not, in the example we used and the problem we're talking about, none of that would be covered here because we said nothing about litigation expenses. If what we were talking about was, paying a filing fee or something like that, clearly that would be covered in the pre-existing version of 1.8E. But E4 now is the new provision. A lawyer providing legal services without fee, a not-for-profit legal services or public interest organization, or a law school, clinical, or pro bono program may provide financial assistance to indigent clients, but may not promise or assure financial assistance prior to retention or as an inducement to continue the lawyer-client relationship. Funds raised for any legal services or public interest organization for purposes of providing legal services will not be considered usable for providing financial assistance to indigent clients, and financial assistance referenced in this subsection may not include loans or any other form of support that causes the client to be financially beholden to the provider of assistance. So we can see that what the scenario described, the simple scenario of giving financial assistance to a client does seem to be acceptable here. The client is being provided the services without fee. There's no promise or assurance of financial assistance prior to retention, or at least none that we're aware of. It's not an inducement to continue the lawyer-client relationship. Now, we were talking about, the funds being sort of unlimited, and yes, on paper, it would seem that this provision it poses no limits on the lawyer providing assistance. But I think what the rules are getting at towards the end is, that we should not cause the client to be financially beholden to the provider of assistance. At some point, if the benefits are large, if the assistance the client is receiving is large, there might be, and what the rule there is getting at is, at some point, does the provision of this financial assistance sort of turn a little bit and become almost like a tool that the lawyer can use to ensure that the client is, does the lawyer's bidding, right? That the client feels that he or she can't, disagree with the lawyer, or doesn't want to fall in ill favor with the lawyer for fear that the money will no longer be forthcoming, or that the lawyer may say, hey, remember all that money I gave you, I want you to pay it back now. So there certainly is a risk in providing the benefits that the relationship, it will change the relationship. And I think that, and because in the relationship, the client is supposed to be in control of the objectives of the representation. If somehow this money changing hands creates tips the scales one way or the other, so that the client is no longer independent, feels dependent on the lawyer, feels like he or she can't object to the wishes of the lawyer, then you would have a problem. So I wouldn't go as far to say that there are no limits on the benefits that a lawyer can provide to the client. We would fear that if the assistance became significant, that it might change the relationship and might really change the power dynamic between the lawyer and the client, which is what that last line is supposed to get at, even if it's not so direct. Now, some of the other things that you raised, Caroline, are excellent points. Would her justice be able to take a donation from the lawyer as in a way so that the lawyer could take a tax deduction for doing that? I would say absolutely. There would be no problem with doing that. Does the assistance have to be in the form of a gift card, or you could only use it at Target for groceries or at the local grocery store? No, I don't think you need to do that. Could you limit the support in some way like that? Sure, but you wouldn't have to in any stretch. Now, let's talk about the second piece of what we discussed, which is the obligation or not to assist the client with the unemployment benefits. No, you wouldn't be under an obligation to do so if what you're doing is practicing law. Then you would want to get some kind of retainer, and obviously do the duty of competence and confidentiality. All that would attach to any formal legal assistance that you gave to the client. Now, you can give advice to a client to help him or herself, represent him or herself. Pro se assistance is always acceptable. You would still want to make sure that the advice given is competent. So if you are inclined, we're in a helping profession. We want to help our clients. If you are inclined to provide assistance in an area where you might not have the requisite competence to provide assistance, then make sure you associate with somebody who does have that competence, and that you ensure that the assistance provided is in fact helpful and competent, because you don't want to put the client in a situation where he or she is worse off by the assistance you provide. There can be instances where the representing a client in one kind of case can impose an obligation on the lawyer to at least advise the client of their rights in other settings. So there are cases where a lawyer who handles workers' compensation cases, the courts have said that it is malpractice to fail to advise the client that he or she might have a third-party personal injury action. If someone's injured on the job by a third party, or there's some third-party liability, a construction worker is using a jackhammer and the jackhammer, malfunctions. They certainly can't, because the workers' compensation system, sue their employer, but they might have a personal injury action against the manufacturer or seller of the jackhammer. So in that setting, courts have found that a lawyer who says, I'm going to handle the workers' comp case, has an obligation to advise the client about the potential for third-party actions, even if that lawyer is not going to handle that action. When I used to represent tenants, and they might have a personal injury action against their landlord, if there was a ceiling collapsed, or their kid had their asthma was worse because of bed bugs or mold or something like that. I wouldn't take on their, if they had a personal injury action against the lawyer, but I certainly made sure to advise the client that they might have a personal injury action. And all I needed to do in that setting was to say, you should talk to a personal injury lawyer, make a referral if you know somebody who might handle that kind of case, or simply to the, the city bar's lawyer referral service. That would discharge the lawyer's duties. I would have to, if there was a particular case that any of you were handling and you wanted to know what were your specific obligations in a particular type of case, if you were handling a U visa application, for example, what additional obligations might you have to advise the client about other benefits or obligations they might have or assistance they might pursue. We could talk about that offline, but generally speaking, it's not a lawyer's obligation to advise a client about every type of legal problem he or she might have. So in this instance, with the unemployment compensation issue, there certainly would be, if you were handling a divorce or something else for the client, it certainly wouldn't seem like there was an obligation to represent the client in the unemployment compensation case, nor might there even be an obligation to advise them in any way. Any thoughts or questions or concerns about what we discussed before we move on to
I have a
the next
question.
problem? Yeah, go ahead. Is that Anna?
Yes. Hi.
Yeah.
My
Hi.
camera is off because I'm not in a place in my house that I want to share with the group, but
That's quite all
but
right.
I'm here. Regarding the giving money to a client and that it's not allowed to create a loan or to have the client be financially beholden, I can imagine many of our clients feeling that way anyway. Even if we were to be very clear, this is a gift, please do not pay it back. A lot of our clients are very adamant that they don't like receiving charity. And so what would we do in a situation where the client gets her financial award, that we were trying to help her get in the first place, like her child support, and as a result decides that she wants to now pay the lawyer back the $200 or whatever it was? Would the lawyer have to refuse to take the money back in order to make it not a loan, or could we potentially suggest that she donate it back to her justice? Or how would you handle the client wanting to pay it back even though she wasn't technically required or beholden to do so?
So I read, and I might be wrong about this, I read that last clause to say loans that cause the client to be financially beholden. And I wouldn't say that any loan operates in that way. So you could, if the client says, I don't want charity from you, I feel bad enough, where the current situation that I'm in, I never imagined ever being in this situation, I'm going to pay it back. That's fine. You can, provide the assistance to the client. If they want to pay it back, they can make it as a donation back to her justice. You could say to them, no, it's okay. We have this, assistant, we have a fund that provides help for people. We could put your money into that fund, or do you want to make a donation to another organization? I wouldn't get hung up on if a client says, I see this as a loan, and you can say, that's fine. It can be a loan. If you want it, if you're able to pay it back, when you're able to pay it back, that's fine too. You're not going to pursue the client likely to make sure they pay it back. So I don't read that last clause to say that loans are prohibited. I read it to say loans that cause a client to be financially beholden to the provider, to be prohibited. It's that last piece that matters. So I don't have a problem if the client says, look, we'll treat this as a loan. I don't want charity. We'll treat this as a loan. That's fine. And if the client never pays it back, the client never pays it back. Does that answer your question?
Yes, thank you.
Oh, you're very welcome. Okay. Hearing no other concerns, let's move on to problem 2. Now, the next few problems all deal with a particular client. I don't think there's anything necessarily pandemic related about this series of problems, but because I think that they're the type of problems that arise in all sorts of settings, pandemic and otherwise. The other thing I should warn you about, you're not going to like this client very much, and sometimes that happens. But don't be offended by the fact pattern. It's just we tried to create one where people could see some tension in their representation. Okay, so problem 2, your organization represents client A, who is in a contentious custody proceeding against her estranged spouse B. You feel A is very likely to win full custody of the couple's children, but there is a strong likelihood the case will go to trial, at least on the visitation issue. You have entered into settlement negotiations with counsel to B, but they have yet to bear fruit. Your client is insisting on very limited visitation rights for B. You believe she is being borderline unreasonable with her demands, and the court is likely to grant B more access to the children than that which A is willing to concede through the negotiations. You have more experience before the judge who will rule on visitation than opposing counsel, and have some insights into how she may rule if the matter goes to trial. You think there is a risk that the court will award B more visitation rights than his counsel is currently seeking. You advise the client of this fact and warn her that her settlement position is weak. You believe settlement at this point is in her best interest if she wants to limit visitation, but A is unwilling to settle, insisting that the matter go to a hearing. Are you under an obligation to follow the client's wishes and proceed to litigate the question of visitation if you have a firm belief that she is likely to get a less favorable outcome than she can clearly obtain through settlement? Okay, there's problem 2. Michael, send people away. See you all soon. Good work, Michael.
Thank you.
So we won't give them as much time this time, but we should still give them a couple minutes. We're doing totally fine on time.
Good. Yeah, I'm timing them for 3 minutes. When 3 minutes is up, I'll bring them back.
Okay, and then before we move into the third problem, I will read the code out.
Uh-oh, I prematurely left my breakout room. Shoot.
That's okay. We're going to end it in a minute. Don't worry about it.
Oh, I was in the middle of yapping. Okay, sorry.
That's all right. I'll call on you to answer this question then.
No, well,
You can
that's the whole
continue
point.
your yapping.
No, I was in the middle of asking a question, so I can't be the one to speak because I don't know the answer.
Well, then I'll ask you to ask your question.
My much more knowledgeable breakout team were obviously in the know more than myself, but I'll learn, or I guess re-remember in this instance.
Yeah, this is a good one. Mike, do you want to send people back in?
They are back. Yes.
Oh, they're back. Oh, okay.
Yes. I sent. They had a minute to come back in. They're back.
Okay, wonderful. Okay, so Jacqueline or Jackie, can I call on you for this one? Do you go by Jackie or Jacqueline?
Jackie's fine. Jackie's fine.
So
Hi.
what did your group say on this one?
So my group just talked about, I guess, past experience, whether at Her Justice or also in our past private firm work, where this issue came up quite a bit. And really, the only thing that we said would, best steps would be to sit down with your client, write down all, pros and cons, what could happen, all realistic expectations that they have, but also what, could possibly occur in court. And then just to solidify that, put something in writing to cover your basis with your client that we've explained to you, the possibilities of, moving forward with litigation, and we explained to you what our position is, have the client sign that just to get it set in stone that you've gone through all those options with them. But to move forward to the trial if that's what their desire is to do so.
So you don't think it would be appropriate, even when the lawyer believes that it's in the client's best interest, to not proceed to trial? And, any lawyer who's ever engaged in negotiations has been in this position where, they think that, the what can be achieved through negotiation is probably better than what could certainly happen at trial. So you think it's not okay for the lawyer to refuse to proceed with the trial and to say that the lawyer's not going to do that? What do you think?
Right. I think that the only thing that we discussed too is the fact if there is, an actual breakdown of the attorney-client relationship in which, that there, that's now a strain on that relationship going forward, then there might be cause there for withdrawal of representation. But, just a reasonable belief of what may or may not happen in litigation, we didn't think, from first steps is enough.
So I think that's absolutely right. So, and then I like your strategy for, making sure you're going over all the pros and cons, the possibilities that can occur through, taking the matter to a hearing. And I don't know that you necessarily have to get the client to sign anything. Writing a letter or giving a memo to the client to that effect is probably good enough to memorialize the fact that you gave this advice, just to protect yourselves. And certainly there are, cases where the lawyer recommends accepting settlement, the case goes to trial, the client doesn't get what he or she could have gotten through settlement, loses at the trial or wins less than they had wanted to get at the trial, and certainly less than they might have been able to get through settlement. And then they bring a malpractice action against the lawyer saying, well, you didn't advise me of the risks of going to trial, but having memorialized your advice, certainly, in writing and sharing it with the client ahead of time helps to protect you a little bit from those charges. Now, the rule on this does vest the client with the right and the power to accept to be in control over the settlement. A lawyer, I'm not going to read the whole thing, a lawyer shall abide by a client's decision whether to settle a matter. So, as long as you're doing your job, if you're putting the information before the client, making sure they have a good sense of the risks, of the potential benefits, of the potential downsides of proceeding, then you've done your job, right? They have the right to give informed consent as to whether to accept the settlement, but you've got to inform that consent, right? You've got to make sure they understand all the risks and the potential benefits of proceeding, the risks and the potential benefits of settling, right? That's your job, right? And this is, these can be very harrowing experiences for the lawyer, for sure, and I've definitely been there. But in some ways, our job is easier in these settings because we, abide by the decision of the client. If you've done your job, they know the risks and the benefits. It's ultimately their decision. They're the ones who are gonna have to live with those decisions, as are you, for sure, but it's really the client's decision. So I think, certainly putting your advice in writing makes a lot of sense. Sometimes, if the client, goes home, thinks about it, reads your advice, it's a little less in the heat of the moment, that could also convince them otherwise, or they might, share their fears with a friend, and then share your advice with that friend, which of course would breach attorney-client privilege, but that's also, on them. They could do that if they wanted to, but putting that in writing sometimes can, help to convince the client of the wisdom of accepting the settlement, if in fact it is wise. But sometimes it won't. Sometimes the client will go ahead and will be unhappy at the end of the day. But your job is to put the information before the client and let the client make the decision. So now let's modify number 2 in number 3, and we'll get to some of the stuff that you were talking about, Jackie, in subsequent problems. During the negotiations of settlement and the representation of client A, the court has made clear it expects the settlement and will not be kind to anyone refusing a reasonable offer of settlement. The judge believes the parties are not that far apart and cannot understand why there is yet to be a settlement. You know why no settlement has been reached, however. A has several times authorized offers of settlement, but every time after B accepts or requests even the slightest adjustment, A withdraws all or key portions of the offer. You are very concerned the opposing counsel will simply stop cooperating with settlement talks, and the court will find A is negotiating in bad faith. You are also concerned with the amount of time wasted in trying to craft settlement offers only to have A reject them on a whim. When you confront the client on these issues, she says, "You don't get it. I'm just trying to screw over my ex any way I can. I love getting under his skin and screw his rat lawyer as well. They deserve each other. If this upsets them, all the better. I told you weren't going to like this client." So, question, is there anything wrong with the client's approach to settlement? What steps could the lawyer take at this juncture in the representation? Is withdrawal or the threat of withdrawal a viable tactic to rein in the client's behavior? That is, if you think there's something wrong with it and don't think it just goes with the territory in this type of litigation, i.e. it is consistent with litigant behavior in divorce proceedings. So what do you think? What do you think about this approach? How would you deal with it? And do you think withdrawal or the threat of withdrawal is an appropriate measure to take? Now, before we go into the breakout groups, though, I know you're anxious to get to those breakout groups and talk about this problem. I'm going to give you the first of the codes that you will need for CLE credit. So here you go. BQE, as in Brooklyn Queens Expressway, BQE 42, Jackie Robinson's number. So BQE 42 is the first code. And with that, Michael, if you would send people back out to their groups, that would be great. And we will see you in a few minutes. All right, things are going well, Mike. Tech seems to be working.
Yep, all good. All good. No issues.
Awesome. And everyone's checked in and stuff.
Yes, everyone's in their groups.
Will
Everything's
you
looking
do
good.
another attendance when we come back in? Is it you're gonna
Yep,
do three
yep.
altogether?
Yep, I'm gonna send out a poll in a little bit. Well, once
Okay,
everybody's
all
back
right.
in.
So once we come back, I'll pause and say, hey, okay, before we get into this, we're gonna do another attendance poll.
Cool. You don't even have to give them a heads up. We kind of like to, just throw it in there if you know.
Okay.
But up to you.
I'll warn him.
Okay, cool. Or I'll bring them back.
Okay, great. Okay. So Velia, what did your groups talk about? And there's an attendance poll.
Unmute myself, sorry. We thought this one was easier. we thought this one was easy. The conduct is that much more egregious that we felt it was much easier to say, I'm not going to be able to continue to represent you. And then the related thing is, of course, we're going to just try to do it in a nondescript way if we actually had to go to the judge and not say what the reason for it was, which is just a related thing. But most times people will back down.
So you think it's threaten withdrawal first. You say people will back down. Are you saying
I would say
who's backing down here? The,
oh, no, I'm sorry. I
client?
think the client would. I would say I can't take that position, and I don't think it's ethical, and I don't think it's negotiating in good faith. You have a right to do what you want, but not with me, the person doing it. So if you want us to continue to represent you, we're going to have to operate in good faith. And so that she might well change her mind.
Yeah, I think that's right. And so you started talking about, applying to the court to withdraw. And when you said, back down, I thought you meant, sometimes judges will ask for a reason and then back down if you say, Your Honor, ethical
Right, no.
concerns. I thought that's where you were going.
That's a good point, though. Yeah, but you want, I guess, and so I'll take your role, and I'd say, well, we want to be careful. We're not going to reveal attorney-client privilege just because the judge asks us to.
Yeah, that's right. And usually the judge will say, if you said ethical reasons, I'd have to divulge confidential communications. That all should be enough for the
Right.
judge to allow you out of it. So let's look at the applicable rule. See if I can get this going here. A lawyer shall not use means that have no substantial purpose other than to delay or prolong the proceeding or to cause needless expense, right? So certainly these negotiations have no substantial purpose other than prolonging the proceeding or really harming the other side, right? So when we're talking about withdrawal, it's all under 116. I'm not going to read all of the provisions of 116, but here, and this is important, except as stated in paragraph D. Okay, so we'll get to D in a second. So first provision, shall withdraw when can be accomplished. The lawyer knows or reasonably should know the representation will result in violation of these rules. Arguably, we just saw that this representation is a violation of the rules. Lawyer's physical and mental condition materially impairs the lawyer's ability. We don't know that that's necessarily the case, although the client may frustrate you. The lawyer is discharged. Lawyer knows or reasonably should know the client is bringing legal action, conducting the defense or asserting position, or is otherwise having steps taken merely for the purpose of harassing or maliciously injuring. So we could say that B4 certainly kicks in. And if B4 kicks in, you have an obligation to withdraw, okay? Now, it's still subject to D. We'll get to D in a moment. Other provisions under C, again, I'm not going to read all of them. Let's focus on these first three. It can be accomplished without material adverse effect. Client persists in a course of action involving lawyer services. Lawyer reasonably believes is criminal or fraudulent. Certainly possible here. Client has used lawyer services to perpetrate a crime or fraud. Certainly possible as well. Client insists upon taking action which the lawyer has a fundamental disagreement. Okay, same thing. Fundamental disagreement. You don't want your services to be used in this way. All right, so I'm going to go quickly through. I'm going to jump over the other ones. Remember, B and C, our oaths are both subject to D. Even if you fall under one of B or C's provisions, you're still subject to D, which provides as follows. If permission for withdrawal from employment is required by the rules of a tribunal, a lawyer shall not withdraw from employment in a matter before that tribunal without its permission. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. In other words, even if you absolutely qualify under a mandatory withdrawal provision as under B, you still need the permission to withdraw if permission to withdraw is required to come from the tribunal. So certainly in family court, permission to withdraw is required of the tribunal. You proceed in New York under New York law, right? You proceed by order to show cause. We talked a little bit before about, just saying ethical concerns make this application necessary. Most of the time, that should be enough for the court, but sometimes the court wants to elaborate. At the same time, sometimes the court will say, no, tough luck, we're too far along in this case, you're stuck with this case, right? So court can always refuse to release you from the representation. Now, as Villy said, oftentimes, particularly if you're the lawyer, I wouldn't say of last resort, but the client isn't likely to get another lawyer, that may be enough pressure on the client to get him or her to accede to your demands, right? To say like, stop the shenanigans, right? We have to proceed in good faith. Not only am I likely to withdraw if you won't, but the court's not going to like it, and you're actually going to be in a worse place than you were before. So certainly, the first line of defense could simply be to threaten withdrawal and get the client to, to behave appropriately in these negotiations. If the client's not willing to do so, you certainly, in this instance, have grounds to seek to withdraw. Now, some lawyers, given the nature of the type of proceeding, understand that there's a lot of bad blood between clients, understand that this goes with the territory. Your own, feelings towards this, shouldn't override, abusive practices on the part of the client, right? If these such abusive practices are inconsistent with the ethical code, and are likely to harm the client anyway, if the judge is going to see through the client's position as being vexatious, right? As trying to make things just more onerous for the other side with no real no real goal other than to punish the other side. Okay, any other thoughts or questions? Just pipe in. All right, we're going to do one more problem with this client. Let's look at this really quickly. Even when withdrawal is otherwise permitted, so this is 16E, upon termination of representation, a lawyer shall take steps to the extent reasonably practical to avoid foreseeable prejudice to the rights of the client, including giving reasonable notice to the client, allowing time for employment of the counsel, delivering to the client all papers and property to which the client is entitled, promptly refunding any part of a fee, although that's not applicable, right? So you obviously, despite potential bad blood between you and the client, you're still going to cooperate with them in putting forth their defense, assisting them finding other counsel, sharing information that you have that the client needs to make sure that the client is able to put on their defense. Okay, one more problem with this client. You've smoothed out some of the rough edges of your client's approach to settlement and decided to go along with the client's wishes to take the visitation matter to a hearing. As the case proceeds, however, you begin to discover that A has not been honest or entirely forthcoming about many things. For example, she claims B is always violating the visitation provisions currently in place, but she grossly exaggerates the nature of those violations. A will say B was an hour late to a visitation session when he was really 10 to 15 minutes late and had a reasonable excuse for his tardiness. A also insists B never helped in caring for the children while they lived together, but there is evidence B took the children to doctor's appointments, was regularly involved with the children's schooling, the couple assumed shared responsibilities for preparing meals, and so on. You perceive no inconsistency so significant that it raises question as to A's fitness as a parent, but these discrepancies are very likely to raise serious concerns about her credibility at trial, especially if B is able to counter with evidence that he was involved in parenting matters, like obtaining testimony from doctors or representatives from the school that would undermine your client's allegations. In addition, in the early stages of the case, you made a number of representations to the court about such parental involvement or lack thereof. Based on what A initially told you about B's parenting, that now appear to be inaccurate or misleading. So, we don't have to, judge the client. Maybe this is the client's perspective, the client's perception. But in reviewing the record, it seems like, some of her statements are exaggerations, and you worry about the credibility of the client. You also worry about your own credibility. So what is the proper course of action here with respect to the representation of evidence that might occur in the future? Excuse me, let me start again. What is the proper course of action here with respect to the presentation of evidence that might occur in the future? What are your obligations with respect to representations made in open court in the past that might have been inaccurate, even if you believed them to be true when you made those representations? So what do you do with, evidence moving forward? What do you do with representations you've made in the past? Okay, so now discuss that in your group. Michael, send people away. Okay, Michael, you want to bring folks back?
Sure thing.
Okay, let's look at this one. So we've got two different, is everyone back, Michael?
Yes.
Okay, so we've got two different problems here. One having to do with past statements by the lawyer, and the other having to do with, what the lawyer is going to present at trial, and with a concern that this testimony is that evidence is going to be incorrect. So I'm going to call on Richard on this one. What do you think the right course of action here is?
That would require me to know how to unmute. So sorry about
That's
that.
okay.
We were
Yeah, what did your group say?
great question. Sadly, I received a phone call in the midst of my breakout rooms, so I cannot speak for my group. I apologize.
Do you want to call a friend? You want to call someone else in your group?
Anna, are you there?
Yeah, I'm here.
Sorry.
Oh, that's okay. Or unless you meant Anna Maria, but
We've
I
already
guess-
heard from Anna. Let's hear from Anna Maria. What
Oh.
did you think, Anna Maria? I love the elementary school picture.
Hi, thank you. Yeah, I'm sort of snacking while we're doing this, so I don't
That's
want
quite all right.
to force you all to watch me eat.
That's quite all right.
So it's funny, this case example actually came from some experiences of my own when I was at Legal Services. And so the first sort of immediate answer is, fortunately or unfortunately, sometimes it is the client who decides whether to settle or whether to proceed to trial. So you can't necessarily, you can't obviously force a settlement on a client who is not willing to resolve the issue. So that's one sort of quick answer. But some of the things that you definitely want to address with the client is the fact that you cannot make false representations to the court, that you can't knowingly do so. And that if the client were to testify falsely, you would be in a position that you would have to alert the court that information provided by the client was inaccurate or straight up false. And that can be very damaging to the client's case and to your relationship with the client. So as much work as you can put in advance of trial to trying to stave off some of those issues is really critical. The case I had where this was a serious problem, we started sending what we call CYA letters to the client after every trial prep session, after every meeting, sort of restating, obviously in a confidential letter, that trial is against our recommendation, it's against our advice, and here are the problems that we see with your position, and here are the facts that we cannot misrepresent or allow you to testify falsely to, and just sort of keep reiterating that point as much as we could in advance of trial.
Yeah, so that's terrific. What about, and we'll get to what the rule says, but what about the piece that you've made representations to the court that you believed were accurate at the time, but now you believe that they're not accurate? What
Yeah.
do you think about that?
So this can be a little tricky because a lot of it will depend on in what manner and at what stage you made those representations. If it was sort of in an off-the-record conference or in sort of a quick jockeying back and forth between counsel, it may not be a significant issue. But if we're talking about putting testimony or documents into evidence, perhaps in a motion or in a previous hearing, then you may have a more significant concern where you do have to essentially correct the record if you've put into the record information that you now know to be false.
Yeah, I would go a little farther. I just in terms of, I totally agree that if it's on the record, you certainly have an obligation to correct that record. I would go a little farther personally, just in terms of protecting my own reputation. Even if it's been in negotiations or in an informal, whether it's before the court or not before the court, I would still be concerned about making a false statement in, even though I thought I was correct at the time, in negotiations, in more informal back and forth. But let's look at the rule says, and a lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So there we see fail to correct is also unethical, right? Fail to disclose controlling legal authority, offer or use evidence the lawyer knows to be false. If a lawyer, the lawyer's client, or witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. A lawyer who represents a client before a tribunal who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So the reasonable remedial measures can be simply talking to the client, saying, first, as you said, Anna Maria, like, you can't testify falsely, if you're going, through the client's testimony and it seems that, that the client is going to commit perjury, your first line of attack is to say, you can't do that. Tell them the consequences of doing that. You can threaten that you're going to have to withdraw if they insist on doing that. And then finally, your ace in the hole is, and if you ultimately do testify falsely, I'm going to have to report that to the court, right? So the whole point of you testifying falsely is going to be undermined because I'm going to have to give the court the truth. So that should be the ultimate ace in the hole, to say to the client, like, look, you've got to testify truthfully. So that's number one. Number two, the client should respond to these, to these overtures to make sure they testify truthfully. If, it's a client or just a witness and they say they're gonna testify falsely, you don't have to offer the evidence, right? So that's number two. And that's what it says clearly, that you can refuse to put on this testimony. Now, number three, this is an area of law where we require that the lawyer know that the testimony is false or will be false, right? So it's knowingly is always the language. It's not, has a reasonable suspicion. It's that the lawyer knows. Now, if you look at the definition of know from the definition section, Rule 1.0, it says that means actual knowledge, but that knowledge can be inferred from the facts, right? So that in a disciplinary hearing, or if the court wants to bring you up on sanctions, it can infer from the facts, from the information you had, that the facts were in fact false. And an example that is often given is a famous case of U.S. against Wooliger. And there, in a divorce proceeding, a lawyer represents the spouse, a husband, in a very contested, very acrimonious divorce. And the couple are still living together, but the terms are not good on which they're living. And the client walks into the lawyer's office one day with tape recordings. So this is when there's still cassette tapes. Tape recordings of the spouse, the wife, speaking on the phone to her friends, to her priest, and gives them to the lawyer, saying, like, look, there's some really great damning evidence in here. Lawyer says, well, how did you get them? Oh, my client, I'm sorry, my wife gave me consent to record her conversations with her friends, with her priest, right? And the lawyer says, okay, great. You had consent to record these conversations in a two consent party state. of course, right, the wife didn't give the husband in this hotly contested divorce proceeding consent to record her conversation. And yet the lawyer, you know, we inferred from those facts that the lawyer knew that the wife never would have given consent and that the client was lying to the lawyer. So even, you know, that language is very strong, right? That the lawyer has to know that the testimony is false or that the witness is going to testify falsely. But we can infer that knowledge from the truth. We can infer that knowledge from the facts, and also from Williger, the court says, you know, the lawyer can't turn a blind eye to the obvious, right? And so the obvious facts in the Williger case are the lawyer really knew that the client was lying to him when he said he had the wife's consent to record the conversation. So, as Anna Marie said, first, if you made false representations, you should correct them. If the client makes false representations, you have a duty to work with the client to correct those false statements. If they're not going to correct those false statements themselves, you have an obligation to do so. And if it happens, you know, in open court, ask for a recess, talk to the client. Client agrees, okay, I'll correct the record. Is it going to look bad? Of course, but it's not going to look as bad as if you have to tell the fact finder, whether it's the court or a jury, that actually, you know, your client just lied. So that's how we navigate these very difficult situations. Any other thoughts, comments? Just pipe in.
I have a question on that.
Yeah, fire away, Esther.
What happens if the client like truly believes like something, you know, but it's more of a nuance, like maybe a cultural thing, you know, it's got more to do with than just the facts as we see it. You know, it's very nuanced from what she really believed that this was happening and this had happened. And, you know, like maybe a trier of fact is like, no, that's not, you know, what we think of it as like attempted murder or what have you. You know, what would, I mean, what do you do with that? You know, when the client insists, no, I'm going to say it this way because that's exactly what this was.
I mean, I think you can say to the client, it's not going to look good if you frame it that way. But if that's the client's true belief, I don't, you know, you don't have to undermine the client in that situation. If, you know, you can't present false evidence, you know, if your client says, you know, it was 3 o'clock in the afternoon and there was an eclipse, so it was dark, you know, you don't have to then, you know, show evidence that there was no eclipse. That's just the client's testimony, right? It's for the other side to undermine that at that point. If your client truly believes that those are the facts, I don't think you have an obligation to undermine your client's perceptions. Does that answer the question? Mm-hmm. Okay, so let's move quickly because we have too much more time. We have about 20 minutes. So let's look at this one quickly. We won't keep breaking out into groups. I think we'll just discuss these as a group. And I'm absolutely gonna cold call it. Esther, you're inoculated because you asked a question. After a matter is initially screened for representation, the client is accepted as a client of the nonprofit legal services organization with which you are volunteering. In a follow-up call with the client, you are concerned that the client might have an undiagnosed or undisclosed mental illness or cognitive impairment that might interfere with the client's ability to understand what is happening in their court case and or make decisions regarding the representation. What are the steps you could, should, or must take with respect to the representation of the client? Must you pursue the appointment of a guardian ad litem? What flexibility do you have in seeking a third-party assistance in the representation of the client? Are there barriers due to confidentiality in seeking such assistance? Okay, let's go. I'm going to go to the wheel here. Let's see. Diane, what do you think?
So this has come up plenty of times at our
Sure.
office. And what we like to do is see whether or not the client would be willing. So whenever I meet with a client and I suspect some kind of mental health component, I always see if, I ask her whether, and I ask a couple of questions. I'm a little bit different out of the group because I do have my MSW, so I can flag certain things that with my colleagues, just from working with clients, they know what the red flags are as well. But I could flag certain things, perhaps offer her to speak with our social worker on staff, typically, who is, she's always available. But, I would have to get consent for everyone to be able to communicate about her case. So that would be another step. It has happened where the client has refused help, refused to speak with a social worker. So then it makes my job a little bit difficult because, who am I to say? I'm not a mental health professional that can say whether or not she's diagnosed with the mental illness. So I would just have to continue to represent her if I was taking on the case and representing, if I was representing her. Turns out that, we had a similar case like this and the client went to court and the court did consider appointing a guardian ad litem. So if I wasn't able to take the steps in my office to secure some help for her, then we'd have to just play out the case and see how it runs its course in court. And then the court noticed the mental health component and then kind of swooped in and helped us out by appointing a guardian ad litem. So in that case, I think that was the proper course if I wasn't able to get her assistance either through a mental health professional at or our organization or give her some tools and, some referrals to different mental health professionals, because that's what we always struggle with. You give the client these referrals, and if the client's unwilling to connect with someone or to get the help, how do you diagnose the mental health issue? How do you provide the proper representation? So it does come up often. But that's what I've done in the past.
I think that's terrific. No, but you said something important in there. You said you'd have to get the requisite consents.
Yes.
So what kind of consents would you want to get?
So I would want for her to give permission for me to speak with the social worker and for her to give permission for the social worker to speak with me.
You're her justice's social worker or a third party?
Or a third party social worker. So it would be internal as well as external.
So
we've done it that way at the family justice centers and stuff, and that's kind of been the protocol. And it seems to have worked.
So I'm not sure that with an internal social worker, as someone who's part of the firm, right, the Her Justice firm, that you would necessarily need the consents. The client may say they don't want to talk to the social worker. You can't force them to. But let's look at the rule. The rule is actually pretty flexible. So the applicable rule is Rule 1.14. When a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a conventional relationship with the client. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. And this is important now. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6. That's rule governing confidentiality. When taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. So what the rule is saying in a convoluted way is actually, it's as if your client has given you the consent already to share confidential information necessary that you deem appropriate to get the client assistance that the client needs. So it's an end run around the duty of confidentiality. I would argue that you don't need those consents. Now, in terms of, the consents that you said, signing consents to speak with internal social worker, external social worker, if you think it's in the client's interest that due to their incapacity, they're not able to protect their own interests, that you could consult with a third party without a formal consent in order to further the client's interests. If you determine that they do qualify under 114 for this type of intervention. Now, it doesn't mean that you can reveal any confidences. The last line says that you can reveal confidences to the extent reasonably necessary to protect the client's interests, right? So only that information necessary to protect those interests can be divulged. Okay, so 114 is a very important rule and gives the lawyer a lot of flexibility, and even lifts some of the confidential, the protections of confidential communications that the client would otherwise enjoy if you feel the need to divulge that information to protect the interests of the client who's suffering under this diminished capacity.
But Ray, I have a question for you.
Yeah.
It says 3 different times it uses the word reasonability, and I mean, Diane has her MSW. She is in a better position. Me, as someone who doesn't have that experience, what kind of, am I in a position to make a reasonable determination? I don't know how reasonable I am in general, let alone to make a determination of whether or not someone has the diminished capacity.
Well, that you can. I would argue there's 2 different provisions in 1.6. There's another provision which says that a lawyer can divulge confidential information if to do so is necessary to ensure that he or she is complying with the rules. So that is in addition to this provision with 114. I would read those 2 together to say, if you have questions about whether the client's perceived diminished capacity is such that the empowering authority of 114 kicks in, I think you could even consult with a third party for just that question.
Right.
If you didn't feel you had the capacity to make a determination with respect to whether 114 even kicks in at all. So, consulting with, an ethics expert, consulting with a MSW, certainly if there's someone within her justice, that's fantastic. But I would argue that you could even consult with somebody without sharing confidential information about the client to say,
Right.
Hey, I've got this client. Here's how this client is acting. What do you think? Is there enough here for me to raise concerns that they're in some risk, and
Right.
that the provisions of 114 should be activated? Does that help?
Yeah.
Yeah. So I don't, I think lawyers aren't necessarily in the best position to make some of these decisions. But we're not alone. We can consult these other experts, even on the question of whether to consult another expert. All right, so let's move on. Very, very. I'm sure that folks have dealt with this sort of problem. So the plot thickens a little bit. Let's look at what happens with this client as you continue the representation. You call the client to follow up and explain issues with the case. The case will likely take a long time to resolve. The client gets extremely upset and screams, "Why won't you help me?" The client goes on to say that she's gone to many other legal aid offices and no one will represent her. The lawyer calmly reiterates that the organization will represent the client, but there are forces outside of the office's control, namely COVID and a backlog in the courts as a result, that mean the matter is not likely to be resolved as quickly as the client would like. The lawyer thinks the client has calmed down and understands the situation. The lawyer asks if the client understands the situation. The client just says, "Well, it's clear that you just don't want to help me. You're like all the others. You don't think I'm worth your time. I guess I should just kill myself. Will any of you care then?" The lawyer, now shaken, asks the client if she has a plan to hurt herself. The client responds that if she does, she certainly wouldn't tell the lawyer. After trying to de-escalate the situation on the phone for about 45 minutes, the client says she is done with the conversation. The client does not share her plans with the lawyer, and it is uncertain whether the lawyer has been able to convince the client not to hurt herself. Does the lawyer have any obligation to notify anyone about the risk that the client might hurt herself? What might the lawyer do in this situation? What must she do, if anything? So again, not going to go to the breakout groups. Hamra, I'm going to turn to you on this one because I would hope that if a lawyer under your supervision or a PBA is dealing with a situation like this, that they would that this would come to your attention, as I would encourage any lawyer to go to your supervisor and talk to your supervisor about it. But what do you think, Hamra? How would you handle this? Are you with us, Hamra? All right, maybe Hamra
She was
stepped away.
out.
Oh, there you.
She was in and out, so I don't think she's.
Oh, okay.
She was doing something, so she's probably not there.
Who wants to take this one on? What do you think? What's the appropriate course of action? Jennifer, what do you think? Are you with us?
I'm here.
Great.
Hey, there's so many Jennifers in the world. Are you talking to Jennifer Cowan?
Jennifer Cowan.
Okay. So I was actually thinking in connection with problem 5 that in situations like this, it may be a good idea to identify someone with whom the client is close, to whom you're authorized to discuss issues, a family member or a close friend, because that person might be able to help you with an assessment of whether the person has capacity. And so I think that, if you've done that and you have authorization to discuss the legal matter with another person, that might be something short of disclosing this privileged conversation to medical professional, to law enforcement or medical professionals or 911, but also maybe a way to get the client some support.
So I think that's a great strategy when you've got a client where you have concerns about their capacity, having a third party who they trust, who they're happy to, or they're willing to have you, communicate with them, a family member, a friend, a neighbor. I think that's a terrific strategy. So what about, is there anything that the lawyer must do? Hamra, did you come back? I saw you unmute
Yes,
yourself.
I'm back.
Okay.
I'm sorry. Yes, I'm back.
Okay, that's great. What would you recommend in this situation?
I mean, strictly speaking, I don't know if Jennifer had spoken to this, but, I seem to have tied a lot of this to her sharing specific steps towards doing something which she didn't do as a kind of one of the markers or thresholds for making, a determination of the severity of the situation. But fortunately, we have a social worker on staff, and we have in the past engaged her. So asked her to follow up if we know it's a safe number, to repeatedly just to reach out, and to the extent that we have more information about, support systems, if she has other contacts. Usually we don't. It's just the client with whom we have contact. But beyond that, oftentimes, then clients won't call us back, especially as she indicated, she's kind of fed up and done with us at this point. But I would advise staff that up to 3 times at least, whether it's by email, phone, to try to reach out. And then I myself would try to call just programmatically to help engage if there was a reason, to explain the reason why we weren't able to help. But that would be my approach.
Do you think you have an obligation to do anything here under the rules?
I don't think so. I mean, in terms of reporting out, no. I kind of feel like the privilege is still intact, just given how, based on the current fact, been my interpretation. So not having to engage Lynn, I don't think in that situation because of concerns, also depending on the underlying facts and her engagement with law enforcement in the past could be a triggering factor as well.
So the rules are, and this, you know, this is not, it may be comforting or not comforting, but here's what the rule says. A lawyer may reveal or use confidential information to the extent that the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm, to prevent the client from committing a crime, to secure legal advice about compliance with these rules or other law by the lawyer, another lawyer associated with the lawyer's firm or the law firm. So that was what I referenced earlier. But with the first two, you know, even if, you know, I think you're making the assumption, and it's a fair one, certainly, that the absence of specific steps suggests that maybe she's not going to, you know, take action that would harm her. But even if you were absolutely 100% certain, you know, the client was on the ledge and saying that they were going to jump, the rules don't require you to do anything, right? A lawyer may reveal. Now that, you know, you may reveal, you don't have to, you may, you certainly are empowered to do so. Even if it's absolutely certain, okay? The rules also say in the commentary that the decision to not reveal, even in the face of reasonably certain death, is not subject to review, right? So you can't be sanctioned for not taking action. There is not similar language saying that the decision to reveal is not subject to review. So the incentives in place, and we may not like it, this is what the rules say. The incentives in place, at least in New York State, some states are a little different, but the incentives in place are such that they absolutely discourage the lawyer from revealing here, because if the you know, if the lawyer reveals this information and it turns out that, you know, a reviewing disciplinary body or a court, if the client says you violated confidences and you know, seeking damages for breach of fiduciary obligation, that, you know, the decision to reveal, if it turns out that it wasn't reasonably certain death or substantial bodily harm, which was at risk, that the lawyer can get in trouble for having revealed it if they make a mistake as to whether or not the death is reasonably certain. So, you know, I'm not going to defend the rules in this regard, but this is what the rules say. So I would certainly, if you felt that that a client was suicidal, taking, you know, corrective action, talking to that third person, that was brought up before, and maybe even, you know, calling the police or calling a relative is appropriate if you feel that the risk is serious enough that the client is going to harm themselves. And you have this provision. You also have the provision under 114 that we just discussed. We've gone a little over time. You've
Ray, can I ask-
satisfied. I was just going to say,
Can you
if
do the
anyone had
code?
a question, go ahead.
Yeah. So my question is, you know, do you really need to disclose confidential information in order to bring somebody in to support this person? But I think you could make a statement of concern without disclosing the substance of your conversation, which would be enough to trigger a emergency response and not disclose and not run afoul of the rule.
I think you could say you have concerns for your client's safety, and you know, depending on the history with this client, that if you have the you know, if you have a third party who understands what the you know, what those concerns might be, that, you know, this client has, you know, a history of you know, harming him or herself, and then if you know, if it's enough that you are, you have a relationship with the third party to say, I have my concerns, that certainly would be okay if it's enough to effectuate the intervention that you want, if you think it's necessary, for sure. So you could, you remember 114 says, reveal only that information necessary to achieve the goals of sharing the information. And if you don't have to share confidential information and you can achieve those goals, that's terrific. If you're calling 911 and you just simply say, I have concerns, I'm not sure what 911 is going to do, right? But I totally, if you can, first of all, if you can not reveal information and effectuate the goals, great. But remember, 114 also says you should only reveal that which is necessary to effectuate those goals.
Wait, can I add?
Ray,
you have another. We have a second code,
the
right?
last code? Yes,
So the
yes.
second code is 161 GC, as in the street on which Yankee Stadium is located, 161st Street. I know everyone has got that committed to memory. There you go, Caroline. 161 GC, as in General Counsel or Grand Central. Anna Marie, you had a follow-up question.
Yeah, I just wanted to add, I think this issue is especially tough for family law and even immigration practitioners in particular, because it's not just about our client's autonomy and our client-attorney relationship, but also depending what happens, whether you're calling EMS or you're asking for an appointed GAL, that can affect the substance and the of your case or the viability of your client's claims. So, if I'm representing a client in a housing case and I need a GAL, it's not going to hurt the case necessarily. But if I'm representing a client in a custody case, by asking for a GAL or calling EMS on my client because she's threatened suicide, I may have just torpedoed her custody claim. So I think that is sometimes that concern about, that zealous representation and that concern of, if I'm wrong here, I have ruined my client's case, that can sometimes interfere with this decision-making. And I think Richard made the point of what exactly is reasonable? How do you know how are you reasonably certain about anything? And I think one thing that's really important about this rule is the fact that you are allowed to reach out to counsel, other attorneys, other folks that can help you kind of navigate this question, because, I may be worried about my client's custody case, whereas someone else might look at the situation and say, but you have someone who's in dire straits right now, and that really needs to be the focus.
Yeah. Oh, absolutely.
Yeah.
These
And
are
also
all...
to just not only the case, but even if it's not a custody case per se, if the client has minor children and someone calls the police on her and says she's at risk of harming herself, then she could lose her children, whether it's a custody case or not. And so, that's stemming a lot of discomfort for me in this hypothetical, that we might, make that presumption when the client hasn't even said anything in particular about harming herself, but it sounds like a threat to sort of manipulate the lawyer in this particular case.
Yeah. Oh, these are all absolutely very legitimate concerns. That's why these decisions are never easy. You also, bringing in outside assistance is likely to damage the relationship with the client for sure. Maybe it will improve the relationship with the client. The client will say, thank you, you saved my life. I was at a low point. Or they may say, look what you've done. You've ruined my life. You brought in, protective services. I'm going to lose my kids. That's not why I came to you, for the exact opposite reason. Absolutely. These are absolutely all concerns that you will have to weigh in these situations. But it's also, all of these concerns are the concerns that animate the flexibility that these rules offer. There is no hard and fast rule. There is nothing that says you must contact a third party. You must, at least in New York State. Other states, few states are different. There is a requirement. New York State, you're not obligated to make, to call a third party in this situation. And lawyers like that flexibility. It often, when I teach these issues to my students, they're often horrified because they haven't yet, experienced the things that you all have experienced with, dealing with these very complex issues. But that's why there's the flexibility. That, absolutely why there's the flexibility. All right. I'm going to skip through the other things, but I'm going to leave you with this. My email address, which you all know how to get, even if you don't know it, you know how to get it. But there's my email address. I'm always happy to talk to folks. Her Justice, volunteer lawyers, if I can be of assistance to you in thinking through these issues, or if you have ideas for further trainings, I'm happy to help. Always happy to help you all. Michael, do you want closing thoughts?
Yes, real quick. Thank you again for everybody coming to this, everyone who registered, and everyone who participated. It was, I think it went really well. At the end of this, I will be sending you all an email with 2 survey links. They will have our CLE evaluation. Like I said, please fill that out. We really need it just for our own records and for CLE accreditation. And then there's also a volunteer info sheet. That's more for people who are not Her Justice staff, just to gauge your interest and current relationship with Her Justice. Thank you again. And Rainless, do you have anything else?
But thank you, Michael. The tech was flawless.
Great. I'm glad. All right. Thank you all so much. I hope you guys all have a great rest of the day and rest of the week. And take care.
Thank you so much.
This is great.
All right. Bye-bye.